The Federal High Court sitting in Abuja has adjourned the alleged terrorism, financing, and illegal possession of firearms trial of the former Attorney General of the Federation, Abubakar Malami, and his son to 10th of March for commencement of trial. Director of Public Prosecutions, Rotimi Oyedepo, informed the court that the prosecution needed more time to familiarize itself with the facts of the matter. Senior reporter Celestina Area has details.
Mr. Oyedepo told the court that the Department of State Services, DSS, had recently transferred the case file of the defendants to the Department of Public Prosecutions, DPP, and that office needed some time to study the file. Counsel to the defendant, Adedayo Adedeji, who did not oppose the application, however, urged the court to strike out the matter if the prosecution failed to open its case at the next adjourned date. The judge subsequently adjourned the matter to March 10th for trial and for the prosecution to formally open its case. The DSS had arraigned the former AGF for failing to prosecute terrorism financiers whose case file were brought to him when he was the Attorney General of the Federation. Mr. Malami and his son are also being accused of possessing firearms without lawful authority. The court had on February 27 admitted Malami and his son Abdulaziz each to 200 million naira bail with two sureties each, of whom must own landed property either in Aibru, Maitama, or Asukuru districts. Justice Abdul Malik had said that the title of the property must be deposited with the Deputy Chief Registrar of the court along with a valid international passport. Besides, Malami and his son were also ordered to submit an international passport and recent passport photograph to the court. Celestina Iria, TVC News, Abuja.
Well, let's now bring in lawyer Professor Fasa Yusuf, who joins me live on TVC News at 10 for more perspective. Prof, what is the import of the AGF taking over this case involving his predecessor?
I think fundamentally, it is to give it an additional fillip and to show the seriousness it deserves. Section 174 of the 1999 Constitution, as amended, empowers the Attorney General of the Federation to so do. So basically, the AGF, you must know, has the power to institute, take over, or discontinue criminal proceedings. Secondly, the AGF is empowered to give directions to law enforcement agencies on investigation and prosecution. And thirdly, to exercise control over prosecution in federal cases. So this power allows the AGF to intervene in cases like terrorism, corruption, or other federal offenses. So it's within the ambit of the law, within the ambit of the Constitution for the AGF to say at any particular point in time, especially when it has to do with the federal cases, that is taken over. So nothing unusual, nothing unconstitutional, nothing unlawful.
But Prof, there are people who believe that the case is selective and more of personal vendetta. What's your opinion?
Well, I think it will be too early in the day to say that because a crime is a crime, whether it's committed by a politically exposed person or by a civilian or by a military man or anybody in government. I do not believe in selective prosecution. I do not believe in selective judgment. It's not in our jurisprudence. But the important thing is that a crime has been committed, or in the opinion of government, a crime has been committed. A crime does not know anybody. It does not discriminate against anybody. So I don't think it's right to say that it is selective, unless you are saying that that person has not done anything. He's just being victimized or whatever because of his political belief or economic belief or social belief. But importantly, once the crime has been committed or there's a prima facie case, that is, on the face of it, it is seen that a crime has been committed. So the prosecution will try to establish this case, and the defense will try to exonerate himself or herself. So at the end of the day, that is how you have the judiciary to interpret and to make pronouncement.
And Prof, this case, the charge against the former AGF, and his son have to do with alleged terrorism financing and illegal possession of firearms. And I'm just curious, does the transfer of the case to the office of the AGF underscore the importance of the office of the Attorney General of the Federation?
Don't forget that the Attorney General of the Federation is the chief law officer of the country. And therefore, the prosecution of federal cases are within his purview. He may decide to delegate his power to his Director of Public Prosecutions of the Federation or to any lawyer whatsoever. It does not remove his power to do so. So whether it affects somebody high, mighty, or low, once he believes from investigation that the crime has been committed, the next thing is to prosecute that case or that offense, and it's for the court now to look at the evidence before it to decide one way or the other the type of judgment to pronounce.
Lawyer Professor Fasi Yusuf, thank you very much for your time on TVC News at 10.
Always my pleasure. Thank you.